in future also. Now, today we have amongst us a resource person who has experience of bench as well as bar. We have resource person who has put in more than 18 years of her life to legal profession and is still going strong. Ma'am has been kind enough to share her short profile, but her short profile also is running into 2-3 pages. So I request ma'am and take her liberty to curtail and be a little brief. We have amongst us Anagha Joshi madam, former judge, family court, and presently practicing at Bombay High Court and Pune District Court.
This
Ma'am
much,
has
this much introduction is sufficient. You can skip the entire part because we do have the time limit for the session, isn't it?
so
So the content of session is more important.
So,
Uh,
ma'am, with your kind permission, and then I will request you to please commence the lecture and enlighten the students who have joined in. Thank you,
yes,
ma'am.
that will be nice. Okay, so good evening all. As the introduction has been given, myself, Advocate Anagha Joshi. So today we are going to deal with the Family Courts Act 1984. Now, all of us know the Family Courts Act 1984. The lawyers who are practicing in family courts, they are well versed with this particular enactment, and the aspirants aspirants of this particular exam, family court judges exam, they must be aware of the Family Courts Act. Why? Because essentially you are looking forward for the appointment as a judge to the family court. Please try to understand, and therefore this particular enactment is very important from this for the aspirants of the family court judges exam. So let us start with the enactment. The enactment is of 1984 and it tells us about, or rather it mentions about the establishment of special courts only for the matrimonial matters, only for the matters related to matrimonial issue, and therefore these special family courts are supposed to be established. Now, why special family courts were required? What was the necessity of this particular enactment? So whenever we do think of any of the enactment, always remember that there are certain reasons, there is a background whenever we talk of any enactment. So why this particular enactment was enacted? Late Srimati Durgabai Deshmukh, she was instrumental for this particular enactment of this Family Courts Act. She emphasized the need to establish the family courts, and there were pressure also from the several women associations, welfare organizations, and individuals for the establishment of the special courts. Now, why special courts were required? The special courts were required. The idea behind having this particular enactment and having special courts was speedy, first, speedy, then next is inexpensive relief, third is least formality, and fourth is technicalities. So what was the idea behind this particular enactment? Why we wanted to have the special family courts? Because there has to be speedy remedy, one thing. The remedy which has been given, it has to be inexpensive. That is, it should be cheap. It should not be expensive. Third was least formality. So the formalities like we do experience in the civil courts, criminal courts, so those formalities should not be there, and there should be least technicalities. We know how much technical we do work when we are working in the court, so there has to be least technicality. So these were the reasons why there was a need of special enactment, why there was a need of special family courts. Now if we go, whenever we do study any enactment, essentially we have to start from the objective why this particular enactment came. And as I told you the essentials, why there was a need of this particular enactment. So let us start. An act, what does the act says? An act to provide for the establishment of family courts with a view. What was the view? What has been mentioned in the enactment? What I told you just now was the background why the enactment was there, why the family courts were established. Now what the act says, that I am reading: with a view to promote conciliation. So what was the view? What was the objective? Conciliation, promote conciliation in and secures speedy settlement of disputes relating to marriage and family affairs and for matters connected therewith. So if we start reading the objective of the act which has been given in the act itself, then we do find what is the objective. The objective is conciliation. The matter should be tried to be conciled. I'm not using word reconciliation, because when we talk of a reconciliation, essentially it is aimed towards saving the marriage. Here I'm not talking about only saving the marriage. No doubt saving the marriage is one of the important objective, but it might happen that for some or the other reason marriage cannot be saved. Then in that case, one has to explore the possibility that instead of fighting before the court, instead of putting the entire life in endless litigation, let the parties concile the matter. Concile the matter, that is, even the amicable settlement by way of mutual consent divorce is contemplated. And therefore, what is contemplated? The conciliation and then speedy settlement. See, the and secure speedy settlement of the disputes. Try to understand. And therefore family court is not aimed, family court is not there so that the husband and wife, they will go to the court and they will fight amongst each other for years together. What we are experiencing, being a practicing lawyer, every day we experience that how much bitter the relations have become between the husband and wife. And we do come across with the cases wherein the husband and wife, they are before the court in sometimes 10 years, 15 years, we have experienced that. So that is not the objective of the enactment. The objective of the enactment is conciliation and speedy settlement. Try to understand. And the family court judge who is supposed to look into this, the responsibility to achieve this particular objective obviously rests on the family court judge. And therefore, as I said, it is very important to know what are the provisions of the Family Courts Act. Now, as we discussed about the two things which have been mentioned in the act, that is conciliation and speedy settlement. And initially when I said that why the act was enacted, the background, in background I also mentioned about least technicalities. And I also mentioned about the uh, cheap or what we can say less expensive remedy. So when we talk about the technicalities, certain rules of procedure are being relaxed when it comes to the Family Courts Act. Try to understand, Family Courts Act is a procedural law. Family Courts Act is not substantive law. The substantive laws which we are going to use in the family courts, they are different. They are matrimonial laws, like we know the Hindu Marriage Act, we know the Divorce Act, we know Christian Marriage Act, we know Parsi laws related to Parsis, we know Special Marriage Act. So all those enactments, they are the substantive enactments. And the relief under those substantive enactments, that relief we are going to claim before the family court. And when the parties are in the court with this particular claiming a particular relief or objecting a particular relief, what procedure the family courts are supposed to follow, that has been mentioned in the Family Courts Act. And therefore I said that the Family Courts Act is a procedural enactment and it is not substantive law. Please try to understand, it is procedural law. It tells us about the procedure that has to be followed by the family court judges as well as the litigants as well as the lawyers when a particular matter is being taken up, when is conducted before the family court. Now, certain aspects which can be dealt on your own, which really need not be discussed in detail, that I'm not going to discuss. And out of that, the definition part I'm going to skip. I will directly go to the uh, appointment of judges. What are the criteria for the appointment of judges? Or rather, I will first start with the establishment of family courts. For the purpose of exercising the jurisdiction and powers confirmed on a family court by this act, the state government, now who is supposed to establish the family court? The state government, after consultation with the High Court and by notification, shall, the wording used is shall, as soon as, maybe after the commencement of this act, establish for every area in the state comprising a city or town whose population exceeds 1 million a family court. So this particular act says that wherever the population exceeds 1 million, the state government shall establish the family court. So for the cities where the population exceeds 1 million, it is obligatory on the state governments, and for rest of the other areas, it is not obligatory, but yes, state governments can establish the family courts. So the subclause of this particular section B may establish family courts for such other areas in the state as it may deem necessary. And that is why I said wherever the population exceeds 1 million, it is obligatory. For rest of the other places, the state government may. It is not obligatory, but yes, state government may establish the family courts. And while establishment of the family courts, the state government is to consult the high court. So now since we are in state of Maharashtra, obviously the state of Maharashtra is supposed to have consultation with the high court of Bombay. So now what are the requisites for the family court judges? Appointment of a family court, the state government may, within the with the concurrence of the high court, appoint one or more persons to be the judge or judges of a family court. Why I am reading certain sections, that I will let you know. Being lawyers, we know that one word may change the entire meaning of the section, or one word may change the interpretation of a particular section. And to understand the Family Courts Act, like other enactments, it is very necessary that you understand the Family Court Act, you learn the Family Court Act through sections. Merely because someone says something, like I will be coming to that particular part little later, but I will tell you that many a times, as a while practicing before the family courts, we normally make a statement that CPC is not applicable to family court. We usually make a statement that Evidence Act is not applicable to family court. So whether that statement is correct, whether that statement is correct in entirety, or whether there is any other part involved into that we are going to deal with. And that is why I said that we need to discuss this particular enactment with the sections. So as far as section 4 of Family Courts Act is concerned, I am directly going to subsection 3. What are the qualifications? What are the essential requirements? A person shall not be qualified. As I said, what are the qualifications? A person shall not be qualified for appointment as a judge unless, so in this particular section, the qualifications are being given, has for at least 7 years held a judicial office in India. So either the person should have held the judicial office, or the office of a member of a tribunal, or any post under the union or state requiring special knowledge of law. So please try to understand, the post which the person has held has to have should require special knowledge of law, or has for at least 7 years been an advocate of a high court or of two or more such courts in succession, or possess such other qualification as the central government may, with the concurrence of the Chief Justice of India, prescribe. In selecting persons for appointment, now see, this is about the qualifications. What should be the qualifications? Now it might happen that a person has the requisite qualification. However, all the persons having qualification obviously are not going to be selected as a family court judge, and therefore the person should have some other qualities to be appointed as a family court judge. And therefore, what are those other qualities that we need to understand in selecting persons? So the first part was the qualification. Now here I will discuss about the selection criteria. So what is the selection criteria? Every endeavor shall be made to ensure that persons committed to the need to protect and preserve the institution of marriage and to promote the welfare of children. Now see, first criteria is protect and preserve institution of marriage. No doubt the society needed the provisions of divorce. Society needed the special family court, and therefore they are established. However, we know that institution of marriage is the base of Indian society, let it be any religion. And therefore, when the person is to be selected, essentially what has to be seen is he or she is committed to to protect and preserve the institution of marriage. Obviously, we do the family courts, they do deal with the custody of a children, they do deal with the access of a children, and many issues related to children are dealt with by the family court judges. And therefore, to promote the welfare of children and qualified by reason of their experience and expertise to promote the settlement of disputes. Now the next criteria, as I said, trial of the matters for years together before the court is not contemplated, but the settlement is contemplated. And therefore, along with the preservation of the institution of marriage, the interest of children, etc., etc., it talks about the settlement of disputes by conciliation and counseling. So these are the essential, these are the selection criteria, I would say, and preference shall be given to a women. Then the age criteria, no person shall be appointed as or hold the office of a judge of a family court after he has attained the age of 62 years. So the maximum age limit is 62 years. Now, next part is section 5, association of social welfare agencies, etc. The state government may, in consultation with the High Court, provide by rules for the association in such manner and for such purposes at subject to such conditions as may be specified in the rules with the family court. Now, I will take little break as far as Family Courts Act is concerned. Along with Family Courts Act, one needs to understand the rules framed for the family courts. There are special rules framed for the family courts in Maharashtra also, and the family courts, the family court judges, the lawyers, the litigants, they are supposed to conduct their matters as per whatever has been mentioned in the rules. And therefore here it talks about the rules. The rules which are mentioned in this particular section are nothing but the rules framed for the family courts. So what does it say? Institutions or organizations engaged in social welfare. We know that our family courts, now I do work in the Pune family court. Those who are working in the Mumbai Bandra family court, or for that matter any other courts, we do come across with the NGOs, we do come across with the social organizations which are associated with the family courts. Why? With what right these particular associations are associated with the family courts? They are associated with this particular provision, and this is the provision wherein the family courts, they can take help of some third person, that is NGOs or social welfare agencies. Persons professionally engaged in promoting the welfare of the family, persons working in the field of social welfare, and any other person whose association with the family court would enable it to exercise its jurisdiction more effectively in accordance with the purposes of this act. Uh, Honorable Dere Madam, in her lecture, the very first lecture, she had mentioned about, if you remember, some sort of activity, I think, regarding the Swayam Siddha or something like that, which has been started in the family court. So how come that activity was started in the family court? That activity was started in the family court because of this particular section. So this particular section empowers the family court, empowers the judge of a family court to take help of the third person. The agencies might be the NGOs or social welfare agencies, or even the private person, if at all that particular that particular help is going to uh, fulfill the needs, or if that is required for whatever has been mentioned in the family courts act. Now I will directly then the next section talks about the counselors, officers and other employees of the family court. The section 6 itself tells us that the state government should appoint the counselors, and therefore we do find that the counselors are there in the court. And normally we do find that whenever a matter is filed in the court, the first step that is done is the matter is sent to the counselor instead of trying it on merits. Why? Again, because the settlement is important. Reconciliation or conciliation is important. So let the councillors first handle the matter and then let the matter come to the court. And therefore, the Act itself has made the provisions for the appointment of the councillors. Now I will go to the jurisdiction part. Now, Section 7 of the Family Courts Act tells us as to what kind of subject matter. As I told you, the Family Courts Act is the procedural law which tells us about the procedure that is to be followed by the family court. Out of this procedure, Section 7 tells us about the jurisdiction of family court. So what are all the matters over which the family courts have the jurisdiction that has been mentioned in Section 7? Understand, rest of the other matters which are not mentioned in Section 7, they are not supposed to be conducted by the family court judges. इस यहाँ पर कोई ईगो नहीं है, मतलब family courts, why family court should not entertain those matters? They are also court, they are equivalent to district court and all that stuff. That has no meaning. Why? Because we have to go by law. Law is supreme and no one is above the law. And therefore, whatever has been mentioned in Section 7, only those matters can be dealt with by the family courts. So what are the matters? Have and exercise all the jurisdiction exercisable by any district court or any subordinate civil court under any law for the time being in force in respect of suits and proceedings of the nature referred to in the explanation. Now see, family court judges, they are supposed to have the jurisdiction of district court and therefore we do call them as a district court. So also they are supposed to exercise the jurisdiction of the lower civil judiciary also. What is important is the matters that are dealt should have been mentioned in the Section 7. Similarly, we know that family courts, they do exercise the jurisdiction of judicial magistrate first class also, because the family courts, they do have the jurisdiction to entertain the maintenance matter under CRPC, under section 125 of CRPC. We know that. And after the DV Act, Protection of Women from Domestic Violence Act, wherever the matrimonial petitions are pending, the DV Act, it says that in a pending petition, the certain reliefs under the DV Act can be claimed. And for that matter, the family court becomes judicial magistrate first class. So family court exercises these jurisdiction. Try to understand. So what all the matters? A suit or proceeding between the parties to a marriage for a decree of nullity of a marriage, that is declaring the marriage to be null and void, or as the case may be, annulling the marriage. Now what is the difference? Declaring the marriage null and void, this means the marriage which is void ab initio. Now the acts, if we go by the Hindu Marriage Act, let us take an example. Then Hindu Marriage Act tells us which marriages are void ab initio. And similarly, Hindu Marriage Act tells us which marriages are not void ab initio, but they can be declared as void, that is voidable marriages. And therefore, two categories are being mentioned: declaring the marriage to be null and void, or as the case may be, annulling the marriage, that is voidable marriages, or restitution of conjugal rights, or judicial separation, or dissolution of marriage. So first category of jurisdiction, first kind of suits, rather I would say. The next kind of suits is a suit or proceeding for a declaration as to the validity of a marriage or as to the matrimonial status of any person. Please try to understand. Validity of a marriage. This does not talk about void marriage, voidable marriage, divorce, because that has already been mentioned in the previous section. Now this talks about the validity of marriage and it talks about the matrimonial status of a person. Now, as I said, this is merely a procedural law and therefore here will come in picture the Specific Relief Act. Because whenever we talk of the declaration of a status of a person, essentially Specific Relief Act will come in picture. And therefore I said that the substantive laws which we are going to use before the family court, they are different. And the Family Court Act cannot be considered as a substantive law. Why I am emphasizing this again and again? Because many a times I have seen petitions titled petition under Section 7 of Family Courts Act. Wrong. Family Courts Act is not a substantive law. It's merely a procedural law. You have to tell the judge under which law, under which substantive law you are claiming the relief. Okay, and if you go through the various divorce laws, various marriage laws, then in that case you will come to know why I am saying this. So next is, as I said, it is regarding the declaration of validity of marriage, or for that matter, the matrimonial status of a parties. Then a suit or proceeding between the parties with respect to the property of parties or either of them. So if at all the parties, they do have joint property, they do have separate property, and then there is a suit, there is a dispute between husband and wife, then in that case the matter can go to the family court. However, please try to understand, a suit or proceeding between parties to a marriage. So what is important is, if you are claiming any relief in the property, any right in the property, then only parties to a marriage can go before the family court. No other person, relative cannot go before the family court. But I will compare this section with the previous section. A suit or proceeding between the a suit or proceeding for a declaration as to the validity of a marriage. Here it does not say parties to the marriage. So try to understand, and that is why I said that you need to read the law section wise, and therefore in this lecture also I am reading it section wise. I could have said this, I could have told this as a lecture, but I am not doing that because I want to show you how to deal with that, how to do that exactly. Then next is a suit or proceeding for an order or injunction in circumstances arising out of marital relationship. So any suit arising out of marital relationship, if it involves a relief of injunction, then that will go to the family court. Then suit for a declaration as to legitimacy of any person, suit and proceeding for the maintenance, suit relationship in relation to the guardianship of a person or custody or access to any minor. And the next it talks about the suits the application for maintenance under section 125 of CRPC. So these are all the matters which the relief in respect of which can be claimed before the family court. No other relief can be claimed before the family court. Though section 8 talks about the exclusion of jurisdiction of rest of the other courts. Now we know section 9 of CPC, it tells that the civil courts have the jurisdiction to try all the suits of civil nature unless barred by law. Now here matrimonial matters like divorce, judicial separation, restitution, injunction, custody, all these disputes, all these suits, they are of a civil nature. However, wherever family courts are established, section 8 of family code has taken away the jurisdiction of the civil court, and therefore section 8 talks about exclusion of jurisdiction of pending litigations as well as filing of a new petitions. So wherever the family courts are established, now whatever matters I just now mentioned, whatever matters are included in the section 7 of Family Courts Act, they are to be tried only and only by family courts and not by the civil courts. Now procedure. What is the procedure? Now as I said, this act tells us about what the procedure the judge should follow, the litigant should follow, the lawyer should follow. So duty of a family court, see the caption of section 9 itself, it starts, the caption itself, it says duty of a family court to make efforts for the settlement. So caption पढ़ने से ही हमें समझ में आ जाता है that what is the objective, settlement. So what is the duty of the judge? Duty of the judge is to settle the matter. In every suit or proceeding, endeavor shall be made. The wording used is shall. It is not may. And all of us know that when the word shall is used, how to construe it, how to interpret it. When the word may is used, how to interpret it. Endeavor shall be made by the family court in the first instance where it is possible to do so. Now see, it is what happens is we don't read the law in its entirety. We don't read the section in its entirety. So the next is very important. Where it is possible to do so, consistent with the nature and circumstances of the case, to assist and persuade the parties in arriving at a settlement in respect of the subject matter of a suit or proceeding, and for this purpose a family court may, subject to rules made by the High Court, follow such procedure as it may deem fit. Now see, family court can follow its own procedure when only for the purpose of settlement of the matters, and that too if the matter is of that nature. It does not say that all the matters, but normally the matters that do come before the family court, they are of that nature, that there might be some exceptional matter wherein the settlement, it should not be sent for the settlement. So normally, why the family courts can have its own procedure for the purpose of settlement, and that too subject to the rules, what the rules they do mention. As I said, the rules are prescribed, so family court judges, they can have their own procedure, but not in anything and everything. If in any suit or proceeding at any stage it appears to the family court that there is a reasonable possibility of a settlement between the parties, the family court may adjourn the proceedings. Now, in CPC, we know that when the adjournment can be granted, when the adjournment is allowed. However, what does this particular act says that if there is a possibility of amicable settlement, then at any stage that is, even if the evidence of the parties is recorded, even the matter is posted for the judgment, at that particular stage also, if the judge feels so, the judge may adjourn the matter. Why? Again, if there is an element of settlement. The power conferred by subsection 2 shall be in addition to and not in derogation of any other power of the family court to adjourn the proceedings. Family court has got other powers also to adjourn the proceeding, and therefore they have made it specific clear. Now, what is the procedure? As I said, again and again we are talking about the procedure. So section 10 of the Family Courts Act, it tells us about the procedure. Subject to other provisions of this act and the rules. Again, see, as I said, again and again it talks about the rules. So you need to go through the rules which are framed for the family courts. The provisions of the Code of Civil Procedure and of any other law for the time being in force shall apply, subject to other provisions of this act and the rules. The provisions of Code of Civil Procedure and of any other law for the time being in force shall apply to the suits and proceedings other than the proceedings under Code of Criminal Procedure before a family court, and for the purposes of the provisions of the code, the family court shall be deemed to be civil court. So it specifically says that CPC is made applicable to the family courts. The only thing is subject to rules framed under the Family Courts Act. Similarly, next section it says that the CRPC is made applicable to the family courts, like as I said, section 125 of CRPC, maintenance applications, they will be governed by the provisions of CRPC. So nowhere Family Courts Act says that the CPC is not applicable or CRPC is not applicable. What does it say? It says that subject to rules framed by the High Court. So whatever the section is saying, we are not supposed to take a section blanketly. We have to consider it, we have to read it as a whole. Nothing in subsection 1 or subsection 2 shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter of the suit or proceeding, or at the truth of the facts alleged by one party and denied by other. So family court can have its own procedure again when, if there is a chance of settlement, one thing, and to extract the truth. So these are the only two cases wherein the family court can go beyond the CPC. Family court can go beyond the rules framed under the Family Courts Act. Otherwise, family courts essentially are dealing with the what we can say, they are the judges, they are the courts, and therefore the rules of natural justice, opportunity of being heard and everything, the CPC and CRPC, the rules of CPC and CRPC are framed by keeping in mind the rules of natural justice, and therefore the rules of natural justice has to be followed even by the family courts. Next is proceeding to be held in camera. Now we know that family courts essentially they do handle the very personal matters, and therefore if the party is not uh, uh, a party is feeling that his or her matter should be heard in camera, if party is not uh, party does not want his or her matter to be heard in presence of the third persons, then in that case the family court shall hear the matter in camera. Please try to understand. I'm not reading the section, but the wording used over here is shall. So the family court has no choice if the party says that my matter should be heard in camera. Why? Because the Family Courts Act is enacted to give justice, is enacted to give uh, what we can say. Relief to the litigants, not only by giving them the speedy disposal and cheap remedy, etc., etc., but the parties who are appearing in the court, they should feel free also. They should feel comfortable also. Because the parties who come before the family courts, they are not usual offenders, or they are not the persons, they are not the litigants like our normal civil matters, and therefore they should be treated on some different angle, and therefore we do find all those provisions. Assistance of medical and welfare experts. In every suit or proceedings, it shall be open to family court to secure the services of medical expert or such person, preferably a woman where available, whether related to the parties or not, whether related to the parties or not, meaning thereby if at all family court feels that he or she should take the help, the assistance from the relative of a party also, the family court is free to do that. Try to understand. However, when uh, a person including a person professionally engaged in promoting the welfare of the family, as the court may think fit, for the purposes of assisting the family court in discharging the functions imposed by this enactment. Now see, such kind of provisions we don't find in CPC, we don't find in CRPC, and that is the nicety, that is the difference as far as family courts are concerned and ordinary courts are concerned. Why family courts? Why family courts judges should know something else than that of the other judges? Why they are not governed by the CPC, strict rules of CPC? Why not by strict rules of evidence? The answer lies over here. Because family, see, being a family court judge is not an easy job. Because as I said, essentially we have to work, the family court judges, they have to work within the framework of law. We do have the law. As I said, the substantive laws are there, the enacted laws are there. So the judges also, litigants also, and the lawyers also, they can't go beyond the law. They have to be guided by the law. And at the same time, while dealing with the law, while dealing with the provisions of the law, in family court essentially the one has to deal with the emotions of the parties also, and therefore that particular job becomes more difficult as compared to the other litigations. I would say that is my opinion, that this is why the special provisions, some what we can say, certain different provisions they have been put in the Family Courts Act. Right to legal representation. All of us know that the lawyers, they can't appear before the court by way of right. That is, a litigant can't appoint a lawyer by way of right. Why? Because the objective of the family court is, first is settlement, that the parties, they should not come before the court, or they should not contest their matters for the years together like the other legal matters. That is the first objective. Another objective, we are talking about the uh, uh, chief justice. We are talking about less expensive procedure. Now when are we talking about less expensive procedure? The parties should be entitled to deal with their cases on their own. They should not enter into the complications, complexity of provisions of law and everything. That is the reason. And as I said, the main emphasis is on the settlement. The main emphasis is on the conciliation, and therefore lawyers are not allowed to appear by way of right. And therefore, we know that whenever we need to appear before the family court, we need to seek a special permission that the party should be allowed to be represented by the lawyer, and that is the reason why do we make such kind of application before the court, and why we can't appear like other matters. We just go and file our VP and we do appear before the court. So that is not allowed as far as the family courts are concerned. Special permission is required to be taken, provided that if the family court considers it necessary in the interest of justice, it may seek the assistance of a legal expert as amicus curiae. Now, it might happen that the parties have not asked for the legal assistance. However, the judge feels that no, some or the other kind of complication is there and it is necessary that amicus curiae should be appointed. Then in that case, on its own, the family court judge can appoint such kind of amicus curiae. Now, next is application of Indian Evidence Act. As I said, the rules of technicalities were to be liberalized was one of the objective of establishment of the Family Courts Act. So if we go by the rules of technicality of the Evidence Act, we know how complex the Evidence Act is. So if we start applying that complex rules, proving, disproving and all that stuff to the evidence, then in that case, the very purpose of family courts establishment might get frustrated, and therefore this particular section 14, it tells us as to how the application of Evidence Act is modified. I'm using word modified. It has been liberalized as far as family courts are concerned. A family court may receive, the wording used is may. Try to understand. It does not say family courts shall receive. A family court may receive as evidence any report, statement, documents, information or matter that may in its opinion assist it to deal effectually with a dispute, whether or not the same would be otherwise relevant or admissible under Indian Evidence Act. So discretion has been given to the judge as far as accepting a particular evidence is concerned, accepting a particular document as evidence is concerned. So even if a document is otherwise inadmissible, the family courts, they can accept that particular document as an evidence, provided the facts and circumstances of the case require that. So this is how the technicalities. Just now we discussed about the application of CPC and CRPC, and we also discussed about application of Evidence Act. So this is how the technicalities have been tried to be liberalized, and the objective of the Family Courts Act is tried to be achieved. Then record of oral evidence. Now, normally whenever the cross examination is taken in the civil matters, in the land matters, let us say normal civil matters, the signature of party is not taken. However, whenever we do practice before the family courts, we have seen that after the cross examination is over, the judges, they do take signature of a witness also, the person who has been cross examined. Why? In suits or proceedings, I'm dealing with section 15. In suits or proceedings before a family court, it shall not be necessary to record the evidence of witness at length. It shall not be necessary to record evidence of witness at length, but the judge, as the examination of each witness proceeds, shall record or cause to be recorded a memorandum of the substance of what the witness deposes, and such memorandum shall be signed by the witness and the judge and shall form part of the record. So here it says that the signature of witness has to be taken whenever the cross examination is conducted, and therefore why such signature is been taken, and even the family court judge has been given the power to record the cross examination or evidence as a memo. Then next is evidence of formal character on affidavit. The evidence of any person where such evidence is of a formal character may be given by affidavit and may, subject to all just exceptions, be read in evidence in any suit or proceedings before a family court. The family court may, if it thinks fit, and shall, on the application of any of the parties to the suit or proceeding, summon and examine any such person as to the facts contained in this affidavit. Now, what does it mean? Normally, what do we know? Whenever the uh, evidence affidavit is been filed, or if at all a person is saying that he is giving evidence, then in that case that person who is giving evidence should make available himself or herself for the cross examination, that we know. However, this particular act says that if at all the affidavit of evidence is of a formal character, then in that case family court can accept that particular affidavit. However, as I said, the rules of procedure, they are liberalized. That does not mean that family courts can go against the principles of natural justice. And therefore the immediate next section, it says that if at all application is made by the party, then in that case the family court should examine such witness. Then it talks about the judgment, how the judgment should be written. Then next section, it talks about the execution of decrees and orders. It says that the all the maintenance orders passed by the family courts, they should be executed in the like manner as that of a money decree. A decree or an order other than an order under chapter 9 of the Code of Criminal Procedure passed by a family court shall have the same force and effect as a decree or order of a civil court, and shall be executed in the same manner as prescribed by the Code of Civil Procedure. So all the orders, judgments of the family court, they will be governed by the CPC when it comes to the execution of decrees wherever they are of a civil nature, and obviously the provisions of CRPC will be made applicable wherever they are of the criminal nature. That is, again, as I said, section 125 of CRPC orders under that particular part, 127, 128, etc. And now for that matter, Domestic Violence Act. Now appeal, this is very important. As I said, the objective of the family court, establishment of family court and the family courts act itself is a speedy remedy. The parties should get speedy justice, speedy remedy, and therefore there is a provision of one appeal only. If you go through this particular um, section 19, and therefore it is tried that parties should not enter into appeal after appeal, challenging this way, that way. Now we know that unfortunately that has not been followed by one way or the other. We do keep on challenging the orders passed by the family court. However, an endeavor has been made to curtail it. How it has been made? Save as provided in subsection 2, and notwithstanding anything contained in the CPC and CRPC or in any other law, an appeal shall lie from every judgment or order, not being an interlocutory order, of a family court to the High Court, both on facts and on law. So the appeal of family court will directly go to the High Court. And this is how the number of appeals, as I said, has been curtailed little. Okay, then next, no appeal shall lie from a decree or order passed by the family court with the consent of the parties. So wherever consent decree, the divorce by mutual consent or any other consent order is by consent, then in that case, the appeal shall not lie to any of the court. Every appeal under this section shall be preferred within a period of 30 days from the date of the judgment or order of a family court. Now here there is little confusion amongst the lawyers, because for that matter, Hindu Marriage Act, when we talk, because I'm giving example of Hindu Marriage Act because majority of cases are under the Hindu Marriage Act. It says the appellate period is 90 days, and here the appellate period is 30 days. So try to understand that wherever the decree has been passed by the family court, the appellate period is 30 days and not 90 days. So we need to remember as far as appellate period is concerned. Then next is an appeal preferred under subsection 1 shall be heard by a bench consisting of 2 or more judges. So this is how the appeals and revisions, wherever the criminal matters, that is maintenance under CRPC is involved, then in that case we know there is no provision of appeal, there is a provision of revision, and therefore that part has also been dealt with as far as section 19 is concerned. Then section 20, section 21 and section 22. Now section 21 talks about the power of High Court to make rules. Again, I am coming to the rules, and I have told you that we do have the rules framed for the family courts. So the High Courts, they have been given power. The High Court may, by notification in the official gazette, make such rules as it may deem necessary for carrying out the purposes of this act. In a particular and without prejudice to the generality of foregoing power, such rules may provide. For what rules are to be made? Such rules may provide for all or any of the following matters: normal working hours of the family court and holding of the sittings of the family courts, on holidays and outside normal working hours, holding of sittings of the family courts at places other than their ordinary places of sittings, efforts which may be made and the procedure which may be followed by a family court for assisting and persuading parties to arrive at a settlement. So this is important. Rules should give, and if you go through the rules which have been framed in Maharashtra, you will find that every endeavor has been made to see to it that rules of natural justice are followed, one thing, and second thing is that the parties somehow or the other, they will try to settle their dispute. Why this settlement? I will come to that particular point. Why settlement? It is not a question, because what happens is whenever the matrimonial matters are pending, a person will get decree of divorce, let us say on the ground of cruelty. Let us presume on the ground of cruelty. He proved cruelty, he or she proved cruelty before the law and he won the case. Getting divorce, even though the person feels like, yes, I got the justice and I won the case and all that, getting divorce, being divorcee was no one's aim when the person got married. कोई भी डिवोर्स लेने के लिए या तो फिर कोर्ट में जाने के लिए शादी नहीं करता है. They, for some or the other unfortunate reasons, the parties, they do enter the court, they do enter the matrimonial dispute, and nobody is going to gain anything from proving or disproving इसने मेरे साथ ऐसा किया, उसने मेरे साथ ऐसा किया. What is going to be the ultimate result? The ultimate result is going to be the divorce, and therefore that, and what happens is in the whole exercise, as I said, if the parties, they are litigating before the court for years together, 10 years, 15 years, then it is of no use. Their life is wasted before the court. That is not contemplated. अगर हम लोग प्रॉपर्टी का केस कोर्ट में लेके जाते हैं 5 साल के बाद, 10 साल के बाद, if at all we win the case, then in that case some or the other profit, some or the other benefit is going to be there. What kind of benefit a person is going to get by getting a decree of divorce? Mental satisfaction, emotional satisfaction. Yes, मैंने केस प्रूव कर दिया. Nothing more than that. And therefore the life of a person is vested in the litigation, and that should not happen, was the is the objective of the family courts. Let the people start their life afresh. Let whatever had happened in their matrimonial life, let that go meaning thereby let them settle their dispute and let them start their new life. One thing. Another part is, as I said, whenever the parties, they do go before the family court, and therefore you will see whenever the matter is filed in the court, normally what procedure we do follow, immediately on the very first day of appearance of both the parties are sent to the counselor. And even we know that the judges, they don't insist us for filing the written statement. Otherwise, after service of a summons within 30 days and 90 days, the maximum period is 90 days, we have to file our written statement. Over here, we don't do that. Why? Because already the petitioner has come up to the court with the allegations. Now, the respondent will file the written statement. Essentially, in written statement, there are going to be counter allegations. So, allegations and counter allegations, and we say that try to settle the matter. So with allegations and counter allegations, it may happen that the possibility of amicable settlement, which could have been there, went away. And therefore, normally we do file our written statement after the counseling is over. And this is how there are very small rules of procedure which are been introduced in the Family Courts Act, or which have been given in the Family Courts rules. But all those rules, all this procedural aspect, the main aim, the main objective is that there should be conciliation between the parties. Now we know that sometimes it does happen that there are misunderstandings. So after coming to the court, the judge is supposed, the counselors, they are supposed to make parties sit together, sit across the table, and if possible, wash out their misunderstandings. If possible, start their life, newly start their life, I would say, as husband and wife. And therefore, we do find that many courts, many family courts, they do organize the functions wherein they do felicitate the couples who had ended up in the court, who had filed the matrimonial litigation, but ultimately they sorted out their whatever differences were there, and they started staying together. Now, this starting staying together is necessary not only because our Indian society is based on the institution of marriage, but the very important part, that is children. Being family court judge, being family court advocate also, many a times we do come across with the problems that are being faced by the children, because if the parents are litigating, if the parents are fighting amongst themselves, then what happens is, what is the trend we do see? Very few litigants are there who do take all those things maturely. But many a times we have seen that the children are used as a tool. The custodian parent may use, or non-custodian parent may use child against the other spouse. That should not happen. The family courts, they are not there to to look into only the dispute between the husband and wife, only the matrimonial dispute, but the family courts, they are there for the protection of children, interests of children also. And therefore, whenever it comes to the access, whenever it comes to the custody, always what do we say? Paramount consideration is to be given only and only to the welfare of child. And this duty to see the welfare of child is again cast on the family court judge. And therefore, we do find that many provisions, now taking help of welfare agencies, then taking help of medical experts, taking help of even the family member of a litigant, all those powers, they are being given to the family court judge. Why? To achieve this particular object. It is not like फैमिली कोर्ट है तो फैमिली कोर्ट में आप कुछ भी करो. It is not like that. All those rules are being made, all these liberties are being given to achieve a particular objective. And therefore you will find that the family court judges, they, I mean the sitting judges, they do work to achieve this particular objective. And therefore, being a lawyer also, whenever, and that is why I said that that particular statement, that family courts are not governed by the CPC, the family courts are not governed by the rules of evidence. Yes, no doubt. But why? What is the objective behind this liberal approach, that we need to understand? And if we understand the why, if we understand the objective of giving this particular liberal approach, if we understand the objective of having this special enactment, then it will be easy while working as a family court lawyer also in the family courts, and even whenever the person is working as a family court judge, what powers are being given to the family court judge? Wide powers are being given, and those wide powers are being given to achieve the objective, achieve the objective of welfare and well-being of child, and as I said, conciliation, reconciliation, amicable settlement between the parties, etc. Now, like state government, the central government has also been given powers as far as certain aspects are concerned. The central government may, with the concurrence of the Chief Justice of India, by notification make rules prescribing the qualifications for appointment of a judge. So, Section 21 and Section 22 and Section 23, they do talk about the powers vested in the state government, central government, and central government as far as the family courts are concerned. So read the powers, what powers are given to the state government, what powers are given to the central government, because see, this is central enactment, this is not state enactment. But at the same time, as I said, this is procedural law, and procedural law essentially has to have some provisions for the ease of the procedure. Procedural laws, they are for the ease. They are not for the person should not be, or the judges or the litigants, they should not be bound by that particular rules of technicalities. And therefore the state government, with the consultation of High Court, may come up with some amendments, may come up with some special provisions. And therefore please read section 20, 21, and 20, I'm sorry, section 22 to 23, wherein, as I said, what are the powers given to the state government and central government. Different powers are given. State can make rules because it's a procedural law. So this is overall idea as far as the Family Courts Act is concerned. Considering the time limit of 1 hour, I have tried to curtail it. I have tried to discuss each and every provision, or rather I would say important part of each and every provision, and have not gone into the details, as I said, because we do have the time constraints. So thank you very much, Bar Council. I would like to extend my gratitudes to the Bar Council, to the all the dignitaries of the Bar Council of Maharashtra and Goa for giving me this opportunity. Thank you very much. Are we going to have question answer sessions? Yes, any
Hello.
idea? Are we going
Uh,
to have question answer
no,
sessions?
madam. If any questions come in the chat, I'll just check whether there are any questions. The chat
Okay.
is disabled. I'll just tell. Sir, there are. Hello. शरद सर जरा चॅट हे करा ना ओपन करा ना काय आहेत का क्वेश्चन्स बघून घेतो शरद सर madam there is a question on appeal period 30 days or 90 days. I think that question is arising because of the difference in period between Family Court Act and litigation under
Yes. If appeal is against the decree that has been passed by the family court, then the appellate period is 30 days.
So basically their query must be basically on the point that if the decree is under the Hindu Marriage Act.
Let it be under Hindu Marriage Act. The issue is who has decided the matter. If the family court has decided the matter, then period of limitation is 30 days.
There is also a question if litigant requires help of the lawyer since the beginning, then what?
I already mentioned that we do make a see, family courts don't say, family court judges see, we are working in the family court. No, normally the family court judges, they don't tell us that you are not allowed to work. What we have to do is, as I said, we can't appear, we can't just file our VP like we do file it in other cases. We have to take permission from the court that please let me allow, please allow me, or rather not we, not lawyers have to take permission. The litigants, they are supposed to take permission from the court that they should be allowed to be represented by the lawyer. And if that permission is given, then from very first date, the lawyers, they can appear for the parties. That is nowhere that has been said that from the very first date the lawyers cannot appear.
One more question is there on the law point basically is pertaining to second appeal. Whether second appeal can be filed against the
Second,
order of family court.
see, second appeal, the as far as this is concerned, the Family Court Act does not mention about the second appeal, and therefore when we talked about the applicability of civil procedure code, it said that provisions of CPC are made applicable. So CPC tells us about the second appeal, and what CPC tells us that on the law point second appeal is maintainable. So over here also, if we apply the CPC, yes, on the law point second appeal is maintainable.
Section 18 subsection 2, there is a query on that.
Section
18 subsection 2.
Section 18. An order passed by a family court under Code of Criminal Procedure shall be executed in the manner prescribed. Yes, I mentioned that now. If at all the order is passed, uh, like see, family court has a jurisdiction of a civil court as well as family court exercises jurisdiction of a criminal court. Civil court, maintenance under Hindu Adoptions and Maintenance Act, maintenance under divorce laws, child custody, etc., etc., divorce, all those disputes, they are of a civil nature, we know. And maintenance under CRPC, that is governed by the CRPC, and therefore section 18 has made two categories. First talks about wherever the orders are of a civil nature, they will be executed like that of the decree by the civil court, and second says that for execution of order under section 125 we need to look into the provisions of the CRPC.
Madam, there are other queries also, but they are in the nature of seeking advice. So I'm
Hmm.
not taking those queries. As
Okay,
a lawyer of family court, even I understand that we are not here to give personal advice on that. So thank you, madam. I will request the coordinator to give the vote of thanks to the meeting. Sharat sir, प्रणालीला अनम्यूट करा ना सर. शरद सर.
On behalf of Bar Council of Maharashtra and Goa, I express my heartfelt gratitude to our today's chief guest, Advocate Anagha Joshi ma'am and former judge of Family Court Act. She has beautifully explained all the provisions of Family Court Act, which is significant. And ma'am, your guidance, wisdom will resonate with us for a long time after this lecture series, and this will definitely going to help all the participants. I would like to express my gratitude to the chairman of Bar Council of Maharashtra and Goa. I would like to especially thank to Vice Chairman of Bar Council of Maharashtra and Goa, Dr. Uday Varunzekar sir, who is a coordinator of this lecture series, and he has organized this informative lecture series. I would like to thank all the coordinators and last but not the least, all the participants who had participated in this lecture series and given a huge response. Thank you so much for giving me opportunity to deliver the vote of thanks. Thank you.
thank you very much. I once again thank Bar Council of Maharashtra and Goa, and obviously all my colleagues, all the advocates are here. So thank you very much for being patient, for giving me patient listening.
Thank you, madam. Tomorrow we will have a lecture on another important topic from the examination point of view. Only request is that not to send messages in chat during the lecture. The same can be put 10 minutes before the finishing of the lecture so that even the speaker can reply to the same. Once again, thank you, madam.
Thank you.
Sir, close for a meeting.